All right, welcome back. Now let's delve into the topic and the conversation proper. I'll be joined now in the studio by legal practitioner, Mr. Ehidiamen Destiny. Joins me now to do some justice to the issues of the Presidential Election Tribunal and also the Osun State judgment. Good afternoon and welcome to the program.
Good afternoon, Mari.
It's good to have you.
It's a pleasure to meet you.
All right, maybe we should start from the Osun State matter and then move towards the Presidential Election Tribunal.
Okay.
First of all, I'd like to get your general thoughts on that process and the judgment, particularly the issue of the courts mentioning that the numbers should have come from Beavers, if I'm correct. So, what do you make of the judgment?
Actually, what the Supreme
implications?
Court did is actually to give an imprimatur to the innovation in the electoral system, which is the introduction of Beavers under Section 47 of the Electoral Act, the use of Beavers in conducting election in Nigeria. That's what Supreme Court did. Also, another thing again is the proving of overvoting. The means of proving overvoting. Does just bringing in evidence, secondary evidence from the internet, is it enough to prove overvoting? And the Supreme Court says that although the judgment is not at what was specifically dealt with in the Court of Appeal decision, which has been availed to members of the public, is the way the Court of Appeal gave their ratio, which is ratio descended on each of the issues. In the issue of Beaver, the Supreme Court, the Court of Appeal, which now have the approval of the Supreme Court, is that when proving overvoting, you need to bring the Beavers report. The form ECA 8, and in proving forms ECA 8, you must give oral evidence, lead evidence. The meaning of that, the implication of that is that if you are trying to put over voting, all these things which are cumulative together, the Beavers report, the registered voters, and the ECA 8, you must bring somebody from each polling unit that is in contention to speak to that document you intend to tender.
When you say somebody, do you mean the presiding officer or just a voter?
It can be an agent, it can be a voter.
Okay.
To speak to that document as to the authenticity, because the best form of evidence is primary evidence, which is the one countersigned by the police and the polling unit.
All right. So still on the issues that were raised. Speaking on overvoting now, does it mean you said something at the beginning? Is a precedent being set here as to how other similar cases could run? And another question is this the just out of curiosity, is this the first case that has gone to completion since the
introduction of the Electoral Act?
Yes, and Beavers, is this the first one?
This is the first one. This is the first text of the legal test of this 2022 electoral act. This is the first time it has been suggested to electoral test.
Just out of curiosity, what about the Edo State election? There wasn't Beavers.
The
Electoral Act, not Beavers.
No, the Electoral Act has its imprimatur. That's its legal backing. 2022 election.
Okay.
And it affected Osun State.
Okay.
Osun State. I think Ekiti, I don't know whether Ekiti conducted the election before the introduction of. No, the Electoral Act was signed in February. So Ekiti, this is the first, let's say Ekiti and Osun, they are the first time this our Electoral Act 2022 was subjected to legal proceedings. And the result is that Beavers is the major Beavers registration, that's registered voters, voters registered, and Form ECA. Let me explain Form ECA for the benefit of our viewer. Form ECA is that sheet after the counting of the votes in each polling unit, where they say, okay, PDP, this political party, you have this, which is now countersigned by the presiding officer, the agents, and even the police. That is from ECA, that paper that paper, that's from ECA. So these three things, BVAS, voters register, and from ECA, they are the means of proving overvoting or even election rigging. And in doing that, for that, you must lead evidence. That means call a voter or an agent from that polling unit, which is the contention.
Wait, just for a sake of clarity, you said from ECA, it's BVAS, and what was the third one?
Voters registration.
Okay, so I'd like to know, in this particular Osun case,
yes,
you know, there have been talks here and there. I don't know if you can help us clarify.
Okay.
There are talks that the Boyega Oyetola brought some numbers from INEC. Some people say INEC brought two versions. Some people say INEC brought an initial version and they said, no, this is the correct one. You know, I don't know if you can clarify what happened there.
What really happened is that the petitioner, which is Oyetola, brought results from the IRF, certified, INEC certified those programs, that is from them. And Supreme Court say that, according to the Court of Appeal, not the Supreme Court, and which I have read, the Supreme Court decision is not out. We must tell ourselves the truth. But the Court of Appeal decision, which is out, the certified true copy of the judgment, which is available to members of the public, it says that you can't use BVAS. You can't use IRF results. It's a secondary evidence, you know, to prove overvoting. That the best form to prove overvoting, that such IRF, they are subject to manipulation. The best form in proving overvoting is your BVAS, your voters registration, and somebody to speak to that form EC88. Do you understand me? So they brought in certified true copies from the IRF, and PDP and INEC were saying we already have BVAS here. We have voters card. We have from EC8. We have from the. Speak to this one. This is the primary evidence. The other one is secondary. The primary evidence is the best form of evidence to be used in adjudication. I don't know whether you are getting it clearly.
Yes.
No, they now say discard this one, and to further reinforce the argument, they disputed that. And once that in law, since it should have been joined, you are supposed to lead evidence. Call a voter from that polling unit which is in contention, you know, to prove overvoting. So Supreme Court have also said that the best form in trying to prove overvoting, you must lead evidence, that you can't succeed on the weakness of another person's case. Since it's a declaratory relief, you must prove it, lead evidence, you know, let your argument be strong and compelling in proving overvoting in this system. So it's a case of they bringing result from IRF, to that person saying, we have BVAS report, voters registration, and from ECID. They are saying, the INEC and PDP, they are saying, this is the best form of evidence. Supreme Court, the court, look at this, don't look at that. Are you understanding me? When people say no, the IRF, which is not in the Electoral Act, they have to look at it. And the Supreme Court say no, this is what is in the Electoral Act. We have given an imprimatur to voters registration, voters register from ECAA, which is that which I've just explained. That form that is countersigned, where the result scored by each of the candidates is be entered into, and the BVAS, which has electoral approval. Those are the best means to prove voting or even rigging and non-compliance. All
right, a couple of questions there. The first one, the implications for the Presidential Tribunal. You mentioned the issue of IRF. That's the second question. You mentioned IRF is not something about it's not in the Electoral Act.
Value.
Yes, so I would like to get more on that.
Okay.
And then when I say implications, I mean in terms of when the state elections were about to hold, I recall that INEC went to court to say that we need to reconfigure BVAS machines for the state elections. And there was some sort of middle ground reached where they said something about INEC having to provide the data to the parties involved before they carry on. What I'd like to know is that data that was given to the parties, does it count the same as saying I have the information from BVAS?
Okay. But the most important thing that once you have result from BVAS, that is primary. That is the best form of evidence.
Yeah, but what I mean is you don't have to have the machines itself.
No, you don't need to have the machine. It's just the report. You can't carry the machine to court.
Yeah, exactly.
It's the report which is certified by INEC.
All right.
If you have Beaver's report, you have from ECA, and you tally it with the voters register, this is what you need according to Supreme Court. This is what you need. Then the IRF result is probative value by the virtue of this judgment is very low. IRF does not have a legal backing. Let us tell ourselves the truth. It's not in the Electoral Act. It does not have legal backing. What has legal backing is the Beaver's report, the Form ECA, and the voters register. That is what have legal value. So IRF now, for it, how it will correctly affect both the presidential election and the state house of assembly. For those who wants to heavily rely on IRF, you know, it's as if their case is weak. You must rely on the Beaver's report, certified, the voters register, and leading evidence in terms of from ECA, that paper. Somebody will come, hello, I saw it, this is the result, this is the one I have. Haven't countersigned it, I snapped it. It was later mutilated and altered. The person will be subject to the brimstone of cross-examination for the courts to get the truth. So the court is saying that these three things must go together.
And this was what I was just about to ask. When it comes to the Form ECA, if one person says, I saw it, this is correct, the other person says, no, this is not what I... So what happens in that regard?
That's how I say, you must... That's how I'll be saying. I say, you must lead evidence. Leading evidence is scoring oral evidence. Okay, Mr. Ojo, you are in this polling unit. This police unit is a contention. You are the agent of party A. Okay, prove to us that this is not the authentic result. This is the altered, the one that is in INEC, the one that INEC is tendering is the altered one. The person will bring out his own. He can even tender the one he has, and he will be subject to the fire and brimstone of cross-examination. Then the court will not be able to infer whether this person is speaking the truth. They are saying that you must lead evidence. Again, I must say that under one section 137 says that once everything is okay, there's a non-comply, you will bring report from Beavers. But the Court of Appeal, the judgment which I have read, you know, the Supreme Court is not out. It says that once the other party dispute it, give a rebuter as to those documents, you must lead evidence to prove the authenticity of that document. That's what I'm saying now. So like that one, you just brought it that party A is saying this, saying that now there's a conflict. How do we resolve it? We resolve it by oral argument.
All right. So it's very important that I guess the importance of party agents have become very heightened, you know. For parties that do not have people representing them, they pretty much have little or less chances. As
very well. Very well, because if you don't have agents, how will you speak to a particular document? You know?
And just to get it correctly,
it becomes a hearsay. What do you call in law hearsay?
Yes, just for common knowledge.
Okay.
When for me see it is is administered. What is the agent's job? Do they just take pictures, or do they have photocopies? How does that work?
They have photocopies.
Right there and then.
Right there.
Okay.
They their signature is there. They can't sign it. The police, the presiding officer, these three people, they must coexist.
Automatically, if the agent was not there, they have no copy.
They have no copy. They have no copy. And if they are trying to speak to the probative value that the court will attach to that document will be very low, because you are not there. It's like hearsay.
Yes.
Hearsay. So the most important place in the election is the polling unit. From ECA, the result sheet for that polling unit is the building block of electoral adjudication. Since you are proving overvoting, corrupt non-compliance, these are the major things that from ECATV and the Beavers report.
All right, that's fair enough on the matter of Osun. Moving over to the Presidential Election Tribunal now. I'd like to get your thoughts on it. The issues we've just laid out now, I think particularly overvoting.
IRF.
Yes.
Those who will heavily rely on IRF.
Yes.
To their fate. What is their fate now?
Yes.
Okay.
But then again, the question now is overvoting even a major, will I call it, point in any of these petitions?
Of course, it's overvoting in the presidential election.
Yes. Tribunal.
The major contention is that no compliance. That is the gravamen of their petition. No compliance, and 25% in outside. The person who is declared winner was not qualified ab initio to contest the election. Citizenship, which was later brought when they filed their reply to the counter petition. You know, so these are the major issue. The issue of overvoting, I don't think it formed the plaque of the presidential election. What is there is no compliance. Then the person who is declared winner was not qualified from the onset. That's their contention.
All right. You know, we've seen that some parties have withdrawn their cases. I think the APP and Action Alliance. I actually had a conversation with the Council to Action Alliance, SN Obama Babuchi, and he made it seem, or he made it clear that politicians will be politicians, that he was ready, you know, to take the case as far as it could possibly go, but then he was told to withdraw, so he had to do that. Well, I'd like to get your thoughts on what could be the implications, particularly, let's start with Action Alliance. There are cases that the valid candidates of the party were not recognized. The chairman, as you can see in there, Omaje, was not recognized. Now, interestingly, INEC in their response have said that, well, that was a mistake. We thought this was settled. We recognize you as the chairman, but we used the candidates from the other chairman. We thought that was the agreement. Okay. And Action Alliance says no, that's not it. And they were going to go all the way, but then they withdrew. But I just want to see, hypothetically speaking, what could have happened if at the end of the day INEC was found wanting? Does it affect the entire election, or how does that work really?
Law is that a case is an authority for what it decides. Legally, previously, by judicial precedent, it is a political party that go for election. The one that we altered the full election, that will render the election nullity, is when a political party logo is missing from the ballot board, from the voting sheet. If a political party candidate who is registered put forth names to INEC, and INEC omitted that logo of that candidate, the logo of that party from that voting sheet, that will render the election nullity. In Faleke against Yaya Bello, the court says that it is a political party that go for election. Let me also give you an example. Somalia against Shakarao, which is a Kano. What really happened? The facts are very similar. INEC recognized Shakarao as NNPP candidate, but the man had defected to PDP and even tendered his letter of resignation, asked INEC that he is no longer an NNPP member. So INEC refused. They have already uploaded it, they will not change it. But the party went to for election and the party won. And they fought the matter up to Supreme Court. Supreme Court say from the very day the other person tendered his resignation, the other party, they did a primary and nominated another senatorial candidate. The votes given to NNPP cannot be awarded to Shakarao, who has not defected to the APC. this settled the matter. As far as your party logo is on the voting sheet, it is inconsequential who is the candidate at this moment. At this moment, in the view of the decision in Supreme Court of Somalia against Shakara, I think you're able to understand how the law will go. As far as their party, the logo of their party is on that ballot, it's on that voting sheet, there's no issue.
All right, that's interesting. It almost means, that whether INEC recognizes you or not, if the law is behind you, you can almost just go ahead and campaign as long as your party is there. Whatever happens,
that's what I say. A case is authority for what it is. It is the facts that decides the law to be applied. I've just said that if, for example, INEC omitted the name of that political party, the whole election will be nullity. But in this case, whether there were like even SDP, the one from this former minister of petroleum, this political party, I've forgotten the name, maybe I'll remember. As far as your party logo is on the ballot board, because I've just given you the case, Faleke against Yahya Bello. The Supreme Court says it is the party that go in for election. So, Supreme Court also followed that decision in Somalia against Shakara, which is just of recent, in February. The other man has defected from NNPP. He was already nominated and his name was already sent to INEC. He had defected. He wrote a letter to INEC, even told that he had defected. He went to PDP. But INEC said they will not change it because they will not alter what they are doing. And the other party, Somalia, went for election campaign and won. And Supreme Court said no. Even the other person was not even dragging that the votes of NNPP cannot be awarded to somebody who have already defected, submit letter of resignation from the political party. So the issue here is that is their party logo on the voting sheet.
Right, but it raises another question now. Okay. Is there a level of obstinacy from INEC? It seems as though these things are very clear. Why did they allow it to linger this long? I mean, if the senator withdrew he decamped, he withdrew his, why force it? Why allow it get all the way to Supreme Court? Why not simply...
It's INEC. There is stubbornness on their part. It's stubbornnness on their part. Another part, although they also have their own administrative issues and bureaucracy. Maybe they say we have already printed everything, do this, we can't alter it again. That's frustration. But even as that, the last hope of the common man is to go to court, and court did excellent justice. All right,
you raised an interesting issue, and I'd like to see what that could mean. The NNPP have been reiterating one issue that they had during this election, even on this very program. The National Publicity Secretary said that during the meetings leading up to the elections and engagement between parties and INEC, that the NNPP repeatedly pointed out that they had issues with their logo and the way it was represented on the mock ballots that was given to them and everything. And they said this is not how it should be. It's going to confuse people. This is not our logo, or this is not quite the way our logo should be. And they said that to their surprise, when the election held, this is after the elections have held, that the ballots remained the way it was shown to them. And to an extent, they have issues with that, although they have bigger issues across the elections. But that issue they also had was that why wasn't the logo represented in the way that it should have been? Is there? They've not taken any legal steps.
That's what I wanted to say.
Yes, they haven't. But I'm wondering, could they have had a case here? Is it the same thing as removing a party from a ballot?
The word here is omitted.
Omit, okay.
Your name is not, the party logo is not there. Now, NNPP, how is it even sure that is their logo, or that is the one they even submitted? So these are a question of facts and law. The one is this the one you submitted to INEC? Is it to mislead the voter? These are the facts that will be for contention in court. The question, but the one I can authoritatively points to, if the the party logo is omitted, everything is a nullity. Everything is a nullity if the party logo is omitted. That's just it, sir.
That means a repeat or a redo.
That's the law. That's why sometimes in the past you see the counsel for the other party who will try to convince other people, please withdraw it. We know the damaging effects of it, because the law is so clear, crystal clear there. So in the past, that was 2019, they would start, lobbying the other party whose candidate, whose logo was omitted from the the voter sheet. Even in Edo State, my state, in Ekpoma, Esan West, APC, Abi PDP, or NPP, their logo was omitted from the House of this. I think immediately have to cancel the election and reschedule for another day. That is just the law, not who is the candidate, who is the chairman. No, it is a party that go for election. In the case as established in the case of Faleke against Yaya Bello, that was the law. This
is very enlightening. That we see a lot of back and forth with people saying, "No, we are the original." It seems as though it's an issue that can be easily resolved. But I like your general thoughts now, just to end on how you see the presidential election tribunal progressing and what you make of the whole matter, especially with the withdrawals we are seeing. Do you see a point where perhaps you might not see any major, or perhaps you might see some, definitely the major cases, but the other ones, there are a lot of cases. Do you see them all being withdrawn? Or do you see? And also the issue with live coverage. Your thoughts on that?
Okay. This is speculative. You are asking me to be a clairvoyant to know whether they will withdraw their matter. I'm not a prophet. I don't know whether they will withdraw their matter. But in fact, those who have withdrawn their matter, they don't have any cause of action against the respondents. So all those who are saying that their matter is still alive. The matter is still kicking. They can still keep on fighting the cause. But on the issue of live coverage, personally, me as a human being, I would have loved to see live coverage of the presidential election petition tribunal proceeding, so that the public can see. But in law, is it feasible if you look at the avalanche of law? Because if for a matter that party may likely need evidence, I don't know whether you have been to court. I don't know whether you have been when you hear that they say if a witness want to give testimony, they will say witness out of court and out of hearing. After they have administered oaths to the witness, they will tell some witness, please leave the court.
Yes. I've seen that, yes.
Okay. If the tribunal is being televised, don't you think that thing is already defeated? Because the reason for that is that so that you should not form your opinion based on it. Your lawyer will even tell you, that person made a mistake. He's not supposed to say it. He has coached you. Later, you're no longer a witness of truth. And again, people might also advance reason that it may expose the lawyers to dangers, to risk. What of our judges? These are the issues that my Lord will resolve. But other countries like Kenya, their whole election is not long, it's not as laborious compared to our own, which is constitutionally 180 days. Some of their whole, I think, now 14 days. They televise it. But in a complex, heterogeneous country like Nigeria, that's so complex, so much emotions are involved, don't you think that judges who will sit at that table, they will be exposed to danger? That matter that they will lead evidence, witness out of courts and out of hearing. Don't you think they will be coached? They will now become a witness being coached because of what the demeanor of the other person. There will be so much distraction. So these are the things. I'm not prejudicing the court. These are what they will look at. APC say they want to object to it. INEC says they may likely object to it. But let's see. Everything is based at the discretion of this honorable court. For me personally, I would like, so that even those of us who cannot even go to court, we can live stream it. Even young lawyers can learn from it. Even people who have interest in learning about law. But the most important thing is that no matter how you watch it, the judgment is based on the inference of what the judges draw in the weakness or in the summations and argument of the councils.
All right, that's fair enough. It's interesting when you put it like that. I never quite thought about that angle. You know, but there will definitely be arguments for and against, but eventually we'll see. It is something that will be concluded. We'll get to have a concrete answer, right?
I think the APC on Wednesday now, APC may put forth their argument, whether they support it or whether they will leave it at the discretion of the court.
All right.
So it's argument against argument.
All right.
It's very it's 180 days. They will still have enough time to look at the matter.
Indeed. So now, final question. I just want to get your thoughts on this suggestion. This is a suggestion by Senior Advocate of Nigeria about how the process could be better. Okay. Speaking to SAM, Mr. Oba Madu Abuchi, he said, what if suggesting why can't INEC hold elections earlier so that the 180 days somehow falls into a time before inauguration? So take, for instance, if elections are held in, I believe he said August or September, by the time the cases, whatever cases might emerge, run through, they will be done before May.
Okay.
And that it kind of makes it a little bit more feasible for a court to say you didn't win the election, rather than telling an incumbent that, get up off your seats, you didn't win the election. What do you make of that?
Okay, actually, yes, I think I heard the argument somehow. But the fact is that the Constitution guides every conduct. This is what the Constitution says. The Constitution says you should conduct election not earlier than 150 days and not, I think, 100 days before the expiration of the substitute term. This is what the Constitution says. If we want election to be concluded before the inauguration, we need to amend our Constitution. Electoral matters is sui generis. It's according to what is in the law. According to what is in the law. That is how electoral. But again, me too, I have serious issue about that. You know why? Because by the time you conduct election, let's say you conduct election in August, it means that you have reduced the entire 4 years of a holder of office into politicking and an electioneering. Because if a candidate comes in year one, before you can even settle down, look at files, look at report of all the agencies, the ministry, is already 1 year. Maybe the second year he's trying to bring in his principle, because even the budget of that year, he's not the one, who made that the budget. But in this case now, let's say election is done in August. If at the first year he's able to, before he can even settle down, the second year, and know that election will be done the third year, what does it mean? That he will be they will be already planning for primary election. Before you campaign for primary election, he will win it. Which means that the next 2 years is just for politicking. Which there will not be time for governance, no concentration of governance. Are you seeing my rationale? It means that the entire 4 years is discretion. A candidate is trying to contest, win primary before he jump the holder of primary, the normal election. And it should not be good for our democracy. What we are supposed to do is to limit the time for adjudication. That 180 days is too much. Make it 2 months and let the respondent also cooperate.
All right, thank you so much, Mr. Ehidiamen Destiny. It's always great to have you. A lot of people tend to have one way of thinking, but you always bring the other perspective. Thank you so much for coming.
It's a pleasure. It's a pleasure.
All right, that's all we take on this segment of the program. We'll bring you some more reports now as we take a break. When we return, the program continues. Stay with us. We'll be right back.